On Thursday, 16th of July, AHPRA wrote to me and said something quite significant. They said that a gender clinic's website, the first thing most families read before they ever book an appointment, has no obligation to tell people about the risks of the treatments being offered or the alternatives to them. Those things, they said, belong in the consulting room. Today, I want to take that statement seriously, and then I want to show you what is actually waiting in that room. In my audit of Toledo Health Centre, ACON's gender clinic, one of the clearest findings was this. There is no mention anywhere on that website of cardiovascular risks, bone health, fertility, incontinence, sexual function, cancer risk or liver risk, etc. Not qualified, not minimized, absent. My position is straightforward. Section 133 of the national law prohibits advertising that is false, misleading, or deceptive. When you advertise interventions that have permanent effects and you systematically leave out the material risks, that is misleading by omission, according to Section 133(1)(a). And for most families, that website is the only part of the system they can inspect before they commit. AHPRA declined to act. Their key reason was this: the national law does not require advertising about the availability of service to include detailed information about risks, side effects, eligibility criteria, or alternatives for each treatment that might be provided within the service. Those matters form part of the informed consent process between a practitioner and patient. In other words, the website can stay silent. The risks and the alternatives only need to come up once someone has already booked and paid. I want to be clear about what we did and didn't claim because it would be easy to answer a complaint we never made. We never said the law requires a full risk schedule in an advertisement. We said that Toledo's website, read as a whole, makes prominent benefit claims while omitting the qualifications, the risks, the limits of the evidence, the alternatives, and the eligibility constraints, and that the overall impression it creates is therefore misleading, i.e., that is Section 133(1)(a). Now, one feature of this letter that I think matters, it is signed by the Criminal Offence Unit, National Legal Services. Section 133 is an offence provision. Breaching it is prosecutable and carries a penalty. So the question a prosecution unit asks, I assume, is not, is this a website complaint? It is not, should this be fixed? It is closer to, would we run this to a criminal standard of proof in a court against the defendant lawyers? If that is right, this letter is not finding that Toledo's advertising is compliant. It is a decision not to prosecute. AHPRA has not said the website's fine. It has said it will not lay charges. I can't be certain that is the correct reading. But either way, the consequences for families is identical. Let's compare this with cosmetic surgery. Health Direct, the government's own health information site, defines cosmetic surgery as reshaping or changing an otherwise healthy part of the body because of how it looks, not for a medical reason. And anyone considering it is to be told the benefits, risks, and alternatives before they book. Many of the procedures offered under gender affirmation overlap directly with that list: breast surgery, facial surgery, body contouring, etc. The line being drawn here is the medical reason. Gender-related surgery may alter or remove otherwise healthy body parts, but it is classified as treatment for gender dysphoria, a mental health condition, treated pharmacologically and surgically. So here's where that leaves us. A woman considering breast augmentation is entitled to see the material risks before she books. An adolescent considering the removal of healthy breasts is not. Same tissue, same permanence, same different rules. That distinction may have a legal explanation. One would think it requires a clear and defensible one. Which position does AHPRA take? The Commonwealth already knows how to write this. On the cosmetic surgery page, under key facts, right at the top, find out the benefits, risks, and costs before you go ahead. And further down, with its own heading, what are some alternatives to cosmetic surgery? Risks up front, alternatives named. Those are precisely the two things our audit found missing. So the guidance exists. It has been written for tummy tucks. It's not been written for mastectomies or castration. AHPRA has effectively said, don't worry, the rest will be covered in the consulting room, which means the whole weight of disclosure now rests on that process. So let's look at what that process actually is. The national standard comes from the Australian Commission on Safety and Quality in Healthcare, and note that these are the standards written for primary and community healthcare, which is exactly what these clinics are. It defines informed consent as a decision given voluntarily after the person has received accurate and relevant information about the proposed intervention, the alternative options available, the expected benefits, and the material risks, and with adequate understanding of that information. Two of those I'd ask you to hold on to. That's alternative options available and material risks. I'm asking you to hold on to them because there are two models of informed consent in play here. And the one used in gender-affirming care does not operate the same way. Toledo says it follows the AHPRA standards of care. So turn to page 12 of that. At the top of the page, AHPRA reproduces the national definition word for word, including alternative options, accurate and relevant information, adequate knowledge and understanding benefits and material risks. At the bottom of the same page, AHPRA describes what its own model guarantees, that the person receives appropriate information regarding the benefits, risks and side effects. Same page, the alternatives are gone. So let's count it. The standard AHPRA quoted has 6 elements. AHPRA's own description of its model reliably delivers 2 benefits and risks and side effects. Toledo website delivers 1. I want to be precise here because the distinction matters. AHPRA does contain risk information, pages 23 and 24, carry tables of risk and side effects for hormone therapy. What it never sets out anywhere is an alternative clinical pathway. I searched the full standards of care for exploratory therapy, for watchful waiting, and for no treatment as a clinical option. None of them appears. Mental health support does appear, but positioned as a support provided alongside hormone therapy, not as a separate pathway a person might choose instead. Which means the options carrying no pharmacological cost, no material risks, and no side effects at all are the ones never placed on the table. Page 20. This is where the model closes on itself. AHPRA says that mental health conditions, including eating disorders and neurodiversity, are not contraindications for initiating hormone therapy, provided they do not currently impair the person's capacity to consent. So these conditions do not have to be resolved before treatment begins. But that leaves a clinical question unanswered. Any of them may contribute to, intensify, or shape a person's distress about their sex or their body. They may not in every case. The model simply does not require that possibility to be investigated first, which means capacity is being asked to carry more weight than it can bear. A person can have full cognitive capacity to make a decision and still have never been offered a choice. You cannot weigh a choice if you've never been shown. I'm not saying that every clinician working under this model fails to ask those questions. Some will do considerably more than the document requires. My claim is narrower. The model itself does not require them to do so. Then there are the consent forms at the back at pages 73 to 76. These are the ones a patient actually signs. They're the only durable record of what was said. They list named physical effects, and then on everything else, nothing on CAS review, nothing on the York systematic reviews, nothing on the US Department of Health and Human Services review finalized in November last year, Nothing from memory on transition, nothing on the persistence of mental health problems after treatment, nothing on lifelong medical dependency. What they offer instead is a single sentence. Research is ongoing and the provider will monitor. Lawyers I've spoken to describe these as functioning more like waivers than as informed consent documents. This is where AHPRA's reasoning fails on its own terms, and I want to be exact because it would be easier to hear this as something I'm not saying. I am not saying AHPRA misapplied the advertising law. I don't know whether it did or not. I am saying that AHPRA's position rests on a chain. The website needn't carry information because the consent process will, and alignment with OzPath isn't misleading because OzPath is an accepted clinical resource. Every link of that is on the record in the regulator's own words, which means the chain is only as strong as OzPath, and we have just been through what OzPath does. There is one more thing. Under Rogers versus Whitaker, the High Court held that the medical profession does not set the standard of disclosure. A practitioner must warn of the risks a reasonable person in the patient's position would attach significance to, not the risks a professional body's guideline happens to list. Following OzPath is not a defense. OzPath cannot lower the bar, it can only fail to reach it, and so does every clinician relying on it. One last thing, and it comes from page 9. That page sets out the scope of the standards. The model is written for adults. It says the principles can be used with post-pubertal adolescents, but only where the legal requirements of the jurisdictions you practice in are met, and only where separate Australian standards of care and treatment guidelines for trans and gender diverse children, the Royal Children's Hospital guidelines, and as adolescents are met. OzPath names its own condition. Toledo treats under 18s. It claims alignment with OzPath. It does not cite those adolescent guidelines anywhere. It has taken the extension without the condition, and AHPRA accepted the alignment claim without asking. So a question that often arises at this point is why the distinction exists at all. Why altering a healthy body is cosmetic surgery in one setting and medical treatment in another. The justification offering is that the gender dysphoria is a mental health condition arising when a person's internal sense of gender does not match their sex, because it's framed as a psychiatric diagnosis. The treatment pathway is not classified as cosmetic, even when it removes or alters healthy tissue. The distress is located in the mind. The intervention is applied to the body. That framing is contested. Dr. Dion Joseph, a clinical psychologist with nearly 30 years' experience, argues the premise does not hold, that gender identity is not a clinically measurable or scientifically established construct, and that the diagnosis was assembled for the DSM-5 in the 2013 rather than emerging from clinical observation. I will leave that debate where it sits because today's point is narrower. It is this reclassification that carries these procedures outside the cosmetic surgery regime and outside the disclosure obligations that regime imposes. Hope that makes sense. So here is the practical reality. The decision to walk through the door is made on the information a family can see before they book. AHPRA says the clinic is not required to put risk or alternative information there, which means the entire burden of disclosure now sits in a private conversation at the one point in the process nobody outside the room can inspect. And it sits there at the exact moment the family has already chosen the clinic, already made the appointment, already sat down. This is what this presentation is about. The assumption is that gender clinics operate under the ordinary safeguards. That assumption is false. They operate under a model that has removed those safeguards. The Toledo audits and the complaints to AHPRA and the ACC are at aww.org/informed consent. And Dr. Joseph's article is linked in the notes below. Every finding cites the page. I hope this has been useful. Cheers, bye.